Patrick, Fair, Baker and McKenzie, the privacy changes have obviously come in today. What are the top three things that businesses really need to know?
Well, the first and most important thing is that your privacy policy now must conform to the prescribed contents in Australian Privacy Principle 1 and that the prescribed requirements are backed up by significant penalties, including a power by the Commissioner to audit you and a power to make you comply and get your systems and procedures in order. So that's the first thing. You can't just have a privacy policy that has in it what you'd like. You have to actually be conforming to the new rules. The second thing is that you need to deal with collection notices. Under the old law, it wasn't nearly as prescriptive, but now you need to look at every point where you collect personal information from the public, and you have to tell the public at the time or as soon as possible thereafter who you are, why you're collecting it, who you usually disclose it to, and a number of other things. And this requirement has a particular twist in it, that if you're getting the information from somebody other than the data subject, or the data subject wouldn't think you were collecting the information, you still have to give them the notice and you have to tell them the circumstances in which you got it from somebody else. So that's a new requirement that people are really coming to terms with. And the final one is about trans-border data flows. Now, under the new law, there's a requirement that you make sure that the data recipient overseas does not breach the Australian privacy principles, and there are requirements that you put in your privacy policy whether you're sending information overseas, and if so, where, and you also put that in your collection notice. And then, even if it goes bad, even if you've done all that and it goes bad, you're going to be strictly liable for any data breach that happens overseas. Now, I said in my notes, Kate, that one of the things about this is it will bend your mind if you get too close to it, and that's because that requirement can be limited if what you do is restrict the use that the service provider overseas can make of your information to only a very limited purpose, and you prevent them from being able to have effective control of the subsequent handling of that information. So there's some very nice calls as to what you put in your requirements and whether or not existing arrangements with service providers offshore put you into that situation where you have to make those disclosures.
Patrick, do you have any last-minute pieces of advice for companies, given that they need to be complying from today?
I think the first thing is to make sure your privacy policy and your collection notices are right, but after you've done that, you really need to review your systems and make sure that you have a compliant culture within your organisation and you're doing privacy by design, because these requirements reach right into your organisation. One of the things that you can be prosecuted for is putting something in your privacy policy and not implementing it. So organisations now need to be very careful that when they're making statements about how they handle personal information, they are actually going to be doing it within their organisation, and that they can survive an audit which will test whether or not they're effectively carrying out what they promised in their privacy policy.
Patrick, thanks so much for joining us.
My pleasure. Thanks, Kate.